way.
And we are live, Your Honor.
All right. Thank you and welcome everybody to today, January 29th, 2025. I know the agenda says 2024. That was to see if you were paying attention, right, Becky?
Completely and totally my error. Thank you.
No worries. We all knew what it was. It's today. And we'll first call the meeting to order. And we will note those present for the record. As I indicated, Judge Spader, if he is done with his other appointment, he will be joining us, but he didn't expect that to be the case. So we expect that he will not be here. And Judge Rohrabaugh, I am not sure if he got caught up on the bench. I did not hear from him. Becky didn't either, but we'll see if he joins us. Other than that, we have a full contingency of committee members. And so rather than calling a roll, Becky, I'll just note that all other members are here. Okay.
Thank you, Your Honor.
All right. And a first order of business after calling the meeting to order is to welcome Judge Altermat, who is a recent appointee to our committee. I know that he already had an opportunity to introduce himself to Attorney Gentis. Do the rest of you folks know Judge Altermat?
Yes, Your Honor, we've met.
Yes, I know I've met Attorney Plockington. I'm sure I'll have a chance to meet most of the rest of you. I appreciate being here, and I know you're a pretty impressive group. And I would just say that you're taking a huge step down when you lose Judge Abrams and you get me. But nonetheless, I'll do what I can do. So pleasure to be here.
Well, and we're thrilled to have you. So thank you. Next agenda item, approval of the minutes from the October 30th meeting. Do we have a motion?
So motion, Your Honor.
Is there a second? All right, any discussion? All those in favor?
Aye.
All right, it looks like they were all ayes, but I'll just note any objections, any nays?
Not a nay, but an abstention, Your Honor. I wasn't here for 2/3 of it, so I'm not comfortable saying that I agreed with what I wasn't here for.
Understood.
Thank you.
All right, thank you. So then the motion carries with one abstention by Attorney Pocklington. Thank you for that, counsel. All
Just
right.
make that 2 abstentions if you would, because obviously I wasn't here.
Oh,
either.
yeah,
Thank
that
you.
makes sense. The motion still carries, but thank you for that. All right. So Judge Altermat and Attorney Pocklington. So now we move into old business, and we have a couple discussions and a report. On our outstanding recommendations, the committee, the recommendation that the committee be required to notify the plaintiff of sales results, as you know from the prior meeting discussions and the minutes, that proposal was made. Judge Bellis was in favor of it. We submitted it. And I think, Becky, we were just waiting to confirm whether or not that had been put up and running by court operations.
Correct, Your Honor. We were, it was with legal for posting the last time that this committee met, and it has since been posted. I believe the JDCV 81 form. If I recall correctly, top of page 3 was the language change, and I believe we also sent that out to you once it had posted.
Okay, great. Any questions on that one? All right, so that's good. That's one more thing accomplished. So thank you, everybody, for that. And thank you, Becky, for following up on that and noting the resolution for this meeting. Now, the next issue was one that was raised and information provided by Attorney Pocklington. And we did, as you know, the last time the proposal was that we bring that to the attention of Judge Bellis to see if there was any interest in proceeding with that, if there was an appetite for it, so that we would know whether or not it would be something that we should pursue. Just to bring everybody who wasn't here last time up to speed on that. And James, if you want to pipe in on this, feel free, or Becky. But the issue was with the motions to substitute, the way that it appears in the e-filing can sometimes be confusing. It shows currently the original plaintiff and then the substitute plaintiff. There were a few proposals presented by Attorney Pocklington, 3 different alternatives that we had discussed, and we brought those to the attention of Judge Bellis. She did agree that there should be some uniformity, so she was in favor of that. And also mentioned that she felt the issue, and Becky, if I miss anything, let me know, but felt that the issue may go beyond foreclosures and into other areas with the way that the clerks are putting that information in. It may be a little bit unique and different for foreclosures. So because of the issues we discussed last time, what she had proposed is that because she agrees with us that we leave this to her and Becky to deal with the clerks on the mechanism to get this uniform. I did ask her, and she was totally fine with it, if she would hold off on doing that until I had an opportunity to bring this back to this committee to see if there was any additional input. Her suggestion was, in looking at the 3 proposals, and James, please let me know if I state these clearly enough, but the first was a proposal for a complete replacement of the plaintiff with the substitute plaintiff as P1 party. The second alternative, because they're handled different ways by the clerk's office, was an addition of the substitute plaintiff as a subsequent plaintiff. And the third was an addition as the substitute plaintiff as a subsequent plaintiff, and the removal of the prior plaintiff as if they were a withdrawn party. Her thought was that the way that some courts or clerks are doing it with that third alternative was confusing, and which I thought that was the one that we were sort of leaning towards, but she thought it was confusing. But I think, and again, I don't mean to, there could be more to this, but I think that was more because she sees this, which I appreciate, as a more global issue that goes beyond foreclosure. And we had specific concerns about how it's addressed for foreclosure. So her thought was option 1 was better, but she didn't say that was the end all and be all. She just said she felt option 1 might be better, but she's definitely in favor of having this be a uniform issue. So before she implemented anything, I wanted to bring it back to this committee so that if the question, to simplify it, I guess, is if we're still, I believe last time there was consensus that the third alternative was the one that seemed to make sense for our purposes. If that's something that we want to recommend, or if the proposal, and it may or may not be accepted, but if the proposal by her that option number 1 might seem to make more sense, if the committee feels strongly one way or another about that, or if you want to weigh in at all or simply leave it to her. So I'd like to first ask James and Becky to comment if I've missed anything or if there's anything you want to add, and then I'll open it up for discussion.
No, you didn't miss anything from the original proposal, so we're good there.
Okay, Becky?
Sure, Your Honor. I did have an opportunity to look over the recommendation with Judge Bellis and to explore from a technology standpoint at court operations what the options would mean and give her that information. So I did provide that to her. And the concern that we then had with option 1 when we explored it further was that it would be an alteration of the electronic record, which is the permanent record for foreclosures. And I not to speak for Judge Bellis, but I do think that we were then able, court operations that is, able to address her concerns regarding the third option being confusing because that's a clerk's process. If the clerks are given a process and procedure to follow, that they're all expected to do it in the same way, which is what this committee was recommending. What would the enforceability of that process be for the clerk's office? And court operations was able to come up with some solutions for Judge Bellis that would show that we'd be able to monitor that from our standpoint to make sure that we are all, change is hard, and that we're all kind of incorporating the change and moving in that direction. So again, I can't speak for her, but I do believe that at the end of the day, with further conversations with court operations technology and e-filing team, that option 3, which was this committee's recommendation, was very doable from our point of view.
Oh, that's great. That's great news. Thank you for that update.
You're welcome.
All right, any discussion with that? I mean, we may very well just want then to stick with our recommendation and request that proposal, but I would like to hear from any members of the committee that have anything to say about that.
Pardon me, because I'm new to this. Maybe I missed something last month or 3 months ago, but regardless what we do here, it wouldn't change the case caption, right? The original
Right.
plaintiff would stay the same? All right.
Well, the
So-
caption would remain the same, right? James, why don't you go ahead? And it was your idea, so you go ahead and address
Yes,
it.
Your Honor. The case caption would remain the same. The issue was the disconnect amongst the various clerk's office with how the current version of the case was reflected down on the party screen. And one thing that was a growing concern in a couple of places where there were clerks that were using the middle option of just adding the substitute plaintiff as if they were an additional party, is that it maintained the appearances of potentially former counsel that were no longer involved in cases. And while this is not a uniquely foreclosure problem, just to put a bow on that, I think we are probably responsible for the lion's share of substitutions in civil practice because of assignments of mortgage being as frequent as they are. So while it is a bigger picture issue on motions to substitute generally, we're probably responsible for most of it as a practical matter.
Yeah, I think that's a fair statement. Anyone else? Did that answer your question, Judge Alternate?
It did, absolutely. Thank
And
you.
does that make sense?
I would agree with Attorney Pocklington's suggestion we
Yeah.
go with option 3, because if, as an example from the minutes from the last time, if JP Morgan was the initial plaintiff and it just disappears off the docket sheet altogether, yet the case caption still says JP Morgan, it's going to cause somebody like me to wonder so I like option 3 as well, but
Great.
greater powers and I will decide that.
All right. Anyone else want to weigh in? So hearing none, I would entertain a motion to submit our, well, we've already submitted it to see if there was an interest and a willingness to consider. Now that we've come back after having Judge Bellis's input and her being fine with us considering this before she did anything, and I'm glad that she did that. We had the additional follow-up by Becky, so I thank Becky for that. I would entertain a motion to submit the request that we proceed with option 3 to Judge Bellis.
So moved.
All right, that was James. Is there a second?
Second,
Also,
Was that you, George?
yes.
Okay. And any further discussion? All right, all those in favor?
Aye.
All right, I see all hands going up, but I will just ask so the record is clear. Any nays? Any abstentions? Motion carries unanimously. Becky, that's on your plate now, okay?
Yes, thank you.
All right. The next proposal that we had made was relating to the issue of the inconsistency in the timing of the filing of supplemental judgments among the various courts, and the suggestion that we consider some uniformity. Now, you'll recall last time we just preliminarily discussed the issue of uniformity, but didn't discuss of the options which one would make sense if we did propose uniformity, and also how people felt about that, because I know that folks wanted some additional time to consider that and look into things from their end, and I appreciate that. We did, however, as I indicated we would, also float that out to Judge Bellis, who was open to the idea. She asked a very good question. I told her we hadn't gotten there yet. She had asked whether we were considering this to be a rule change, a proposal for a rule change, or whether we'd be asking that it be a standing order. And I told her the great question, but we hadn't gotten there yet because we were still trying to formulate our thoughts on it. And she just suggested that we may want to, if we do proceed with this, we may want to do it in the form of a rule change, which would carry more weight and would allow people an opportunity to address pros and cons. Now, we may be putting the cart before the horse with that, but I did want to throw that out there just so you were aware of the issue. With that, I'll go back to the basic issue, the first one, which is, I know there was consensus last time as reflected in the minutes that there should be some uniformity. And again, Judge Bella seemed to be receptive to that as well. And the question now is whether folks have given any further thought to the various options for the timing. You'll recall that we had discussed a few of the ones that we've seen. Hartford and New Haven are different. Bridgeport is different. New Britain is different. And I don't know what do they do in Willimantic, Judge Altermat, with the timing when you're approving committee motions? I don't think I had asked you that. Do you know what the timing is for the filing of a motion for supplemental
I'll be
judgment?
honest, we're fairly flexible. I mean, we get them and we don't, I mean, once in a while we have to call a committee up and give a little nudge and say what's going on. And sometimes there's a good reason. Sometimes there's less of a good reason, but we don't really have any issue with it. I don't think we've been contacted, you know.
Do you know what your committee, I mean, what your order says though when you're approving?
Yeah, I should know it by heart, but as far as the timing as to when, maybe I should have asked that. When you're saying the
Sure.
timing of the supplemental judgment, you mean after the sale? How
So,
long?
Yeah, so let me just give you a couple examples. Hartford's order is when you approve the motion's approved, the report is accepted, fees are awarded, and then the last provision says the plaintiff is ordered to file their supplemental judgment within 90 days of this notice, or a final disposition of this case will be ordered by the court. In New Haven, and this is why it occurred to me when I moved to Hartford the last time, I was using my standard New Haven order, and the Hartford people were very confused, like, where did that come from? And that's when I realized, and then again, as this committee came back to life, that was an issue that I explored with some of the other courts and noticed that there are a bunch of different ways. So New Haven says the plaintiff is ordered to file their motion for supplemental judgment within 5 days of the committee's return of sale. New Britain makes it 30 days. I can't remember if theirs is from I think it's from the date of the order on the approval. And Bridgeport does it differently. Some of you folks may remember the Bridgeport one. I don't have that order in front of me right now, but there are all different time frames. And again, the statute allows for it to be within the discretion of the court. So if somebody were to be late or needed more time, certainly it's within the discretion of the court to determine. And generally, we're pretty accommodating unless they're grossly overdue. We have had some circumstances where they've languished, but that's sort of the exception and not the rule. And so, but just with regard to the initial order, they're all over the place. And so that's why the thought was there should at least be some general uniformity for the standard order, certainly not to take away the discretion of the court if there's some reason to require something else in a particular case. Does that make sense?
Does.
Okay. With that, I'll ask those of you that were here last time and anybody who has any new thoughts, if you've given any thought to this issue with regard to what would make sense. I know that the thought was there should be some uniformity, but no feeling of which way would be the best way.
Part of the concern with uniformity on this, and I completely agree that it's a necessary element, is that just something I sort of have in the back of my mind while we're thinking about it, the elephant in the corner the elephant in the corner is docket management. It's the discretion of the court in terms of how long a case should be allowed to sit in limbo without forward motion, knowing that the supplemental judgment is likely the last big action in a particular foreclosure matter. And different courts and different judges have very different views on how fast things should be expected to move. And so what the standing orders currently can, just so we're all on the same page in terms of this current version of the standing orders at paragraph 23, is that a motion for supplemental judgment should be filed with the court as soon as possible after the committee conducts the, et cetera, et cetera. So there isn't a given, if we're considering putting a date in there as opposed to as soon as possible.
Oh, I think as soon as possible would probably wreak more havoc, because I know that's what the standing order says, but everybody has certain timeframes. I think the bigger question, and I throw this out there, and if you disagree, please tell me, is would it make sense to have it tied? Some people have it tied, or some courts have it tied to the date of the notice on the approval of the sale. And some have it tied to the date of the return of sale. Now, I know that this, obviously there's timeframes for when the sale needs to take place and all that good stuff too, but it seems that there's a difference there that has an impact on making this even more or less consistent, for lack of a better description.
While I certainly can't speak for the entirety of the plaintiff bar, from a practitioner perspective, I don't think which of those triggering events is used really matters, because the challenge with a supplemental judgment from a plaintiff perspective is, or rather from a plaintiff counsel perspective, is getting the affidavit of debt. And when the figures for the affidavit of debt are requested is not tied to either of those particular dates. It's just a matter of, usually it's the sale approval, internal processes, lender specific timing rules, etc. So it's, if the goal is to use one of those two dates as day zero to start the clock ticking, I don't think
that's the only point.
I don't think it really matters which of those two dates. Frankly, one is, hold on, bear with me 1 second. One is a clerk's office date that's sending the notice of the approval, whereas the return of sale is a committee given trigger, so that if not to go too far down the computer programming rabbit hole, but if the point is to have the ability to pull reports or have a data point in the court's computer system about when this should be done, the filing of the return of sale as it's done by the committee as opposed to something by a clerk probably isn't a data point that's easily mappable or usable by judicial. So I would think that the sale approval, because that is something done by a clerk, sending the notice would be a better system related trigger. And yeah, I totally went all IT on you there. Sorry about that.
Oh, that's okay. So I remember, it's still, the order still says the plaintiff is ordered to file their supplemental judgment within X amount of time. So it's still obviously something that's filed by the plaintiff. The question is, again, just uniformity. And again, that was one part of it, is whether it made sense to tie it to one versus another. But the other part is in some way to make it consistent so that you're not having 30, 60, 90, 5 days from return of sale, that, that kind of a thing. Anyone else?
Again, other than for the sake of uniformity, I really don't perceive any problem with it as is. If I haven't got if I haven't got what I need, I have the clerk make a phone call. Maybe because I'm in a small jurisdiction,
Yeah.
I've got time to do that. But I mean, I don't. It's not a concern. I've never perceived a need for it out here. But again, that's out here.
As you can see, we try to make our committee diverse, both in practice area and in courts. And so it's good to have one of the smaller courts involved too. Attorney General, you indicated last time that you wanted some time to think about this. Do you have anything to add?
I just reiterate what Attorney Pocklington said. It's really, I don't have any issue with uniformity. I can't make any guarantees that things will actually proceed as they should, just based on the fact that most of the hangup is getting a supplemental affidavit of debt from our client, and it's really anyone's guess how long that takes. So I don't have any issue with uniformity. I think that what James was saying with regards to the timing issue for the court, it probably makes more sense to have have had it run from the time that the court takes an action as opposed to when the committee returns the sale to the court, because who knows when that might actually be. So, and it might be easier for the court to track that based on when the sale is actually approved by the court. But in terms of a time frame, it's just very hard to say. We certainly encourage our clients to get these things to us as quickly as possible, but sometimes that doesn't happen as planned. So I did speak briefly to Rachel in our office, who I think Judge Ultimat's probably familiar with, because I think she attends from our office every week in Putnam. So and she does handle the post sale matters, and it's really difficult to set a time frame. Obviously, from our perspective, we'd be looking at as long as possible, but obviously the court wants to have judicious use of the docket and get cases resolved as quickly as possible. So I don't have a time frame, but I do think that it would make sense that if the court is going to set a uniform time frame, it'd be from the approval of the sale. That way it can be tracked based on an order on the docket, as opposed to when the committee may return the sales to the court.
Let me turn to Attorney Salato, and then I will hear from the attorneys who represent the defendants to see what they have to say. Attorney Salato, you have anything to add?
Not much. I mean, at least what I struggle with is that sometimes the committees don't give me notice that they filed their return of proceeds. So unless I'm tracking every case individually, it's just hard to follow sometimes. But I do agree that I think it's best to do it when the court takes action versus waiting on the committee, because they're all so different.
Well, given our success with the prior recommendation that the committee is required to notify the plaintiff of sale results, hopefully that will help with that one. Yeah. All right. And Attorney Gentis, Attorney Sternberg, anything from your side? All right. So
no, this is especially the only thing, if it's tied off committee versus the only other triggers that happen. I think that I just agree that the sale approval makes more sense. It's also,
yeah,
just it accounts for appeals, it accounts for anything else that's going on around. Sometimes objections to sales are made and there's a little bit of a lag, and so why not just tie it to the latest period possible?
All right. So in looking at these, and again, this isn't a scientific study. I looked, as I told you, and I gave you folks the last time all of them, but I only have the few in front of me now. But we looked at the big jurisdictions. We looked at Bridgeport, New Haven, Hartford, New Britain. Those are the ones that I had all showing where things were. And we had, I believe, I can't remember Bridgeport entirely. So please, folks, I could pull it up, but it would probably take me a little while because I'm not as fast as the rest of you, if anybody remembers what that one was. But I believe all of those jurisdictions, Hartford, Bridgeport, and New Britain. I know Hartford and New Britain, but I think Bridgeport too, tied it to the approval of the committee motions. I think, and Becky, tell me if this is your recollection or if I miss this, but I think New Haven is the only one of the ones that we looked at that tied it to the committee's return of sale.
I'm trying to put my hands on those more full notes, Your Honor. I believe that is true. I recall, I think, Judge Spader speaking to it.
Yeah, I think that was the only one. So what I'm hearing, and please tell me if I'm misinterpreting anything, what I'm hearing is that the consensus seems to be that for purposes of uniformity, it would make sense more to tie it to the approval of the committee motions as opposed to the return of sale. Is that right? Please pipe up.
Yes, yeah.
Everyone, anyone? I see nods, but I just...
Yes, my understanding as well, Your Honor.
Okay. And noting that the comment was for as long as possible, of these options, and certainly we're not limited to these, but of these options, it would appear that Hartford gives the longest amount of time, because Hartford allows for 90 days from the date of notice of the approval of the committee motions. So, I mean, I don't want to put words in the mouths of the committee. Do folks feel that it's appropriate to propose that as a it would be again, that doesn't take the discretion away from the court. If there's some reason that a judge feels there's a need for a shorter or longer time, that is within the discretion of the court to do. But as a general proposal, does anyone want to weigh in on that? If that one makes sense.
The big variable, just so we can all have it in the back of our minds while thinking about this, is from a plaintiff practitioner perspective, that what makes a supplemental judgment affidavit one particular supplemental judgment affidavit more complicated than the next is the amount of time and activity since judgment. So a simple no borrower motions to open, no HUD moratoria, no this, no that, judgment entered 3 months ago, fairly routine, fairly easy. Where some of the disconnect of the last couple of years has been obviously is we're finally at the point where we've more or less filtered out all of the pre-pandemic judgments, but all of those files where there were years of postponements, and now we're finally getting to supplemental. Those are fewer and farther between, thank God, but those affidavits of debt are nightmarish to figure out what is properly included, what is not properly included, what was incurred post-judgment, etc. So my thought process is, if we are looking at a date specific as opposed to a general wishy-washy category, like as soon as possible, 90 days is much better than 30 and much better than 60. And I don't think going to 120 would be acceptable to Judge Bellis. So 90 seems as close as we're likely to get.
Anyone else want to weigh in? Nobody?
I would just agree with what James said.
All right.
I would, it seems like an outside limit, and if they need it, they have as much incentive as anyone else to get these things wrapped up. So I know they're trying hard. So if they need 90 days, frankly, if they needed 120, they came back to me on the 89th day and said we need more time, I would, again, I trust them, and I'm sure there's a reason for it. So if I'm hoping most of them come in well before 90 days, but if that seems reasonable to everyone, certainly it will work out here.
Yeah. All right. And again, I know I said this, but I think it bears repeating. This would in no way impact the judge's discretion in doing just as Judge Altermat indicated, which, is easily done. I mean, unless there's some really egregious circumstance, and I can't imagine anybody in this committee, Brady Bunch box, being one of those folks that would be involved in that ordinarily. As long as it's on track, if there's a request made, they're generally, to my knowledge, at least in my court, and I think in most others, that they're generally granted. You folks can tell me if I'm wrong about that. So then, is there a motion to propose what we've discussed, then the tying the approval to the committee motions and basically using, I'll call it the Hartford format, just because that's what was the 90-day one, as the general uniform time frame, subject, of course, to judicial discretion.
What I would suggest, so I gotta phrase this a little bit formally, is that we propose replacing the first line of paragraph 23 of the Uniform Foreclosure Standing Orders. That's the JDCV, let's go back up, 79, with a motion for supplemental judgment should be filed with the court within 90 days of the court's approval of the sale. And the remainder of the paragraph wouldn't need to be changed. But that way it keeps the should from the standing orders as opposed to the must from, I believe that's in the Hartford template.
And then before I ask you if that's in the form of a motion, I think there would need to be something directed to the judges to make sure that their orders were modified. I mean, I know it seems like a no-brainer, but folks have been using certain language in their orders. And so those orders would need to be changed to address that as well. Correct?
Absolutely, yeah.
All right.
And any changes to the standing orders that would impact a JEO template, I would hope would be subsequently updated.
And I know that sounds like a no-brainer, but I just don't want it to go, unsaid and then missed. So is that a motion?
Yes. Yeah. And yes, I don't know if there's a second, but yes, that
right.
would so moved.
Well, if there isn't a second, then the motion will die. So is there a second?
I'd second that.
All right, thank you. Any further discussion?
Let me
All
just,
those,
so,
yeah.
so that this would be then in the way of a change to the standing orders, because you started this discussion by saying Judge Bellis was
One or the
leaning
other, right?
towards she wanted to go the other direction. I don't want to go up against
Well,
Judge
she didn't
Bellis.
want it. No, this committee makes it, it's an advisory committee. She was just offering her input to us, indicating a suggestion. Did we have a decision one way or another, which way we were going to go? I told her that we hadn't gotten that far yet. And she just threw that out, that if we wanted it to have more weight and allow that the process of the rule change. But that was just a suggestion on her part, just for the benefit of Judge Altermat, because I know this is your very first meeting. The process will be that we will, if assuming this motion carries, we have a motion and a second, we're in the middle of discussion, then we'll take a vote. We'll put together a proposal to Judge Bellis to indicate what our proposal is, to see if she agrees with us. If she does, then it gets passed on and sent up to the Chief Court Administrator's office. We make recommendations. We don't implement. It's up to the powers that be to decide whether or not they think this is a good idea and they want us to do it or not. But we generally start by, if there is proposal that comes from this committee, we will first reach out to Judge Bellis to see if there is an interest in our going forward with it. And here we've made it past that. So now we're at the stage of determining whether there is a proposal that we all agree on that we can send to her for review. And if she agrees with us, she may agree, she may to ask us questions. She may say it's not something that, I mean, at this point, I think because there was an initial interest, I don't think she would say that it's not something they're interested in, but I don't want to speak for her. And then once we hear back from her, we'll either come back to the committee to see if there's something else we have to address. Or if she says, yeah, I'm on board with that, then we send the proposal up to the Chief Court Administrator's office for consideration. Does that make sense?
Absolutely.
Becky, did I miss anything? You were trying to unmute yourself.
Sorry, yes, no, Your Honor, sorry. I keep trying to find teams underneath words. So
no worries.
That is the correct procedure. Thank you.
All right, thank you. Any further discussion? All right, hearing none, then I would ask all those in favor signify by saying aye.
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 All right, I know, again, this is just more for the recording than anything else. But I know everybody's hands went up, but I will just ask, any nays? Any abstentions? Motion carries unanimously. We'll put some language together then to get that request off to Judge Bellis. And now we move on to the new business, and we have some reports from, there were proposals made, you'll recall from the last meeting for those that were here, by Attorney Gentis and Attorney Pocklington, and the first, Attorney Gentis, was yours, which was your concern about holding sales at the property. I know that Becky forwarded the PowerPoint that you had prepared. Did you want to have that pulled up for I'm going to turn to you to have you present your issue. Did you want that pulled up?
Sure. And I don't know if it's easier, I can't share my screen, but if there's a way to, and I don't want to I don't want to ask for the sharing power, but I also don't want to.
No, I think Becky, can you do it? I always poor Becky.
I'm working on that, and you can certainly have the sharing power. It's a power we can share if you prefer. That's fine as well.
I just certainly don't want sole power. There's a
We
co-hosting,
will- co-hosting. Let me just.
Whatever's easiest.
whatever's easier. And I just want
I
to say
have-
too that the
Oh,
deck
I-
itself and my approach is like a little bit of a put on in terms of how like flip it may come across. I don't mean it that way. And I am like very interested in like discussion and feedback and appreciate the time and opportunity. There we go. Share. It's lit up. Ooh.
Wow.
All right, here we go. All right, you folks see that?
Yes.
I'm on double monitor, so it's hard for me to tell. All right, so go on what we need to. There. All right, so a few things are unique about the way we do things in Connecticut, some of which we knew and some of which I've learned recently, which has drove me with the passion to make this deck. Strict foreclosure, it is recited often. It's like Connecticut and Vermont. Vermont's really not doing it anymore. And since around like 2005, there was a bankruptcy court decision where essentially the court found that the strict foreclosure was essentially on paper a fraudulent conveyance. It spooked a lot of Vermont lenders, and they are just simply going along with foreclosure sales all the time. So it's really just us. Also, the sign at the property, which I think is between the two things here, sign at the property and the sale on the property. The sign at the property is unusual. I couldn't find any other state that does that. And it spoke to a lot of other practitioners across the country about how we do things. And the sale at the property is, at least in terms of being on the lot, is a relatively unique thing. And then having, the Vermont does sales at the curb, which is somewhat similar, but it's really not quite the same as being on somebody's lawn. Where these things come from, this slide here explains itself. Good afternoon, Judge Rohraback. I've just started, so you.
And my apologies. I was in a hearing. I trust you. I did not have a late lunch. I apologize.
Okay.
Well, no, I had a hunch. I told everyone, they know that we generally, if we're not here, it's because we've gotten stuck on the bench. Thank you for joining. So just to tell you where we are, we've handled old business and we're just starting on the new business. This was Attorney Gent's proposal at the last meeting. He asked to discuss the issue of holding sales at the property. And so he literally just started his presentation.
Thank you.
So question is are these good things? Strict foreclosures, I think, in terms of actually like putting aside the name, and the name's a little antiquated. I'm working on telling more people about it. I think other states that just do purely sales, I think it's ridiculous and wasteful, and I'm not the first person to say that. But I am working on that with other advocates in the country, and maybe next year do a lot more around it. And then I've learned even back when there were more strict foreclosures, including states that had strict foreclosure without judicial sales. That's the reason that our IRS liens requiring a foreclosure sale law came into being back in 1966. But given that there is no state that requires, or that has purely strict foreclosure anymore, and given that the Tyler v. Hennepin County decision involving property tax foreclosures didn't affect us here in Connecticut, but it affected a lot of other states that had functionally a strict foreclosure for tax foreclosures. Maybe there'd be a move, but who knows how to get anything changed at the congressional level, but that's an academic aside. Is the sign at the property a good thing? I contend no. And the sale at the property is a little bit less so, but I still think it's a net negative and not needed. Why the signs and sales are bad. I cannot tell you how many homeowners I've spoken to over the years who are petrified of the sign. Like even as more so than like homelessness or the instability of it. And there are medical consequences to the sort of stress and humiliation and the loss of self that go along with foreclosures. It attracts attention, increased attention within the neighborhood. I don't think it's great for our neighborhood either. Most of the neighbors don't want a foreclosure sign up on the yard. It's not attracting the type of attention or sort of turning the neighborhood in the light that we want. There's also I don't think any other state does this. And when I spoke to, homeowners, largely it's homeowner advocates across the country, they're like, what? what do you, what kind of, scarlet letter type shaming do you do here in Connecticut? It's like, oh, I didn't realize that. And I realize that, especially in a group as experienced as ours, we might feel like we heard this time where a homeowner said to us, I'm here on the motion to open judgment because there was a sign showed up on my lawn, and that's what prompted me into action. I think that's an issue, I'm not going to say it's 0 times, but I think there's also like maybe failures of notice or failures to provide notices in languages people can understand, and some other issues that may be contributing to some of that, but they're very rare. And I say this as somebody I've spoken to more than 13,000 people facing foreclosure, and the times when it made the difference and got them involved in the case, and they were able to get a long-term solution negotiated, are extremely less than a handful. I've talked to committees as well, and they said, look, once in a while somebody will be there. They're usually not there, but sometimes they'll be there and they'll say, walk through the property. I say, okay, that's great, but like by and large, we should be having if folks who have equity should be doing a full-blown sale through a realtor, and this foreclosure sale is often not going to produce, realize the actual equity that they have in the property. And then, yeah, I've explained the shaming aspect to it, that it's not making the difference in the way that we want to. And then the question is how to change it. If you're interested or want to figure out what we would need to do, I think it's straightforward in terms of the standing order. It's not like it comes out of a statutory requirement. So there's the sign, and then there's the where it takes place. And where it takes place is a solvable logistical issue. I think it's relatively straightforward. I know this sounds wild because it may, but you could do it at courthouse steps. You might be like, well, what about the weather? What are we going to do? We don't have a nice overhang here at such and such courthouse. I hear you, but that's what happens now with sales at the property. You're still dealing with all the weather elements and the like. You can think about how do we do with committees. I think these are relatively solvable issues. You could have a few people in charge of the sales that are happening. They're all at the courthouse, maybe different committees. You don't need a single committee managing every single sale that's happening in a given day. I think that's a fixable thing. But for me, especially, if I had to pick two, I'd be getting rid of the sign. People who are learning about foreclosures, by and large, in terms of the buying market, are doing it through the court's website right now, and not the sign on the yard. Anyway, that's it.
All right. So obviously this is the first time that we're hearing this, and it was, thank you very much for putting the time and effort into the presentation. Certainly we're not taking any action today. Yeah. This is just to start getting people to think, and I'll open it up for any preliminary discussion, and then we can put it on the next agenda for people to, after you've absorbed this a little and thought about it, if there's anything else you want to talk about. But I'll open it up now if anybody has any initial thoughts that they want to raise.
When am I ever not willing to talk about anything? So as far as signs are concerned, I've lost count over the years of how many times I've had homeowners or councils say that they first really woke up to an action because of the sign on the property. The state has a extraordinarily strong, some, not necessarily me, but some may say too strong, interest in providing notice. We go out of our way with our judicial process, but everything between you are being sued and in danger of losing your home that is required by law to be attached on top of the writ summons and complaint, through to the various notices sent out by the courthouse, that the foreclosure mediation notices, et cetera, to make sure that homeowners are aware of a pending foreclosure action, to the point where it's sort of a better they get 10 notices than risk not getting one mentality. And that in some ways, the sign on the property is just one of those additional safeguards to make sure that that anyone who is about to lose title to their property is aware. So in that regard, as a matter of sort of public interest and one last chance to know about it, I think the sign is a good idea. But to Jeff's point about embarrassment and whatnot, my initial thought is maybe a change to the standing orders to say that signs are necessary for non-appearing owners of the equity. We already have a specific process that we follow in terms of an additional notice that goes out to a homeowner. And that way, I can't tell you how many times I've had a homeowner ask a judge to waive a sign, and the judge is usually more than happy to do so because there isn't that, it's a safety net concern. They're clearly aware of it. They're there at the judgment hearing. They're asking, why not prevent the anxiety that Jeff is concerned about? So a change to just put signs up for non-appearing may split the baby in a really good way in terms of the public policy both ways. That's my thought as to signs. As to locations of sales, my initial thought is that we have a wonderful resource in our committees. This may be asking a lot of Becky or one of her peers, but I'm concerned about the chilling effect of committee participation in the event that the rules change to require closing, or not closing, but that require the auction to happen at the committee's place of business. Some are solo practitioners that might not have an office suitable to that type of a gathering. The exact opposite of this case, some may be associates in very large firms and big buildings in Bridgeport or Hartford, and the idea of, now if I'm going to have a dozen people in the office on a Saturday, what do I have to do in terms of the building and security and cleaning up afterwards and whatnot? I almost think it may be appropriate as an information gathering tool to maybe do some sort of doodle poll or something like that to our committees to see if that change would be well received or would have a chilling effect before we go too far down that rabbit hole.
Good thought. All right, anyone else?
It only seems appropriate, Judge Baio, that I'm late and then I have the gall to open my mouth. But I'm going to take the plunge nevertheless.
Always a pleasure to hear your thoughts.
So my thinking is, from the 30,000 foot level, is that the sale, the common goal that everyone has in a foreclosure sale is to maximize the value of the property being sold, because that inures presumably to everybody's benefit. The more we get for the property, the greater the likelihood that the encumbrances are satisfied, and the less the likelihood that the debtor is exposed to a deficiency. Can everyone agree to that kind of general framework of what's going on? So I just think, I'm going to count on Attorney Gentes to push back. He'll find something that.
No, I mean, there's a lot in the literature about what the purpose is and what the real purpose is. And so that I agree that is the ostensible goal.
Fair enough. And I mean, that's the I think that's the laudatory purpose, to the extent that there can be such a thing in a foreclosure sale. That's, I mean, the purpose from the plaintiff's point of view is, I just want what's owed to me. I could care less if there's a penny more. It doesn't matter to me.
Yeah,
but,
and they would appreciate it if someone purchased it, even if it's also, there's a disposal element too, like a pure liquidation element. Like, we would love this not to be on our books.
I totally get that, but they're not.
Yeah.
We don't look to them to create public policy.
From your lips to God's ears. But.
All right. So I mean, I don't look to them to create public policy, and so to that end, I just think it's appropriate for all of us to ask the question, whatever is in front of us, will this promote and enhance the goal of maximizing the value of the property, or will it have no effect on it? It's just something that I think about, that I analyzed any potential changes against that question.
Only to just, I spoke enough already, but just on 2 points, I think to James's point in terms of notice, that there are states that do more of a posting on the property for the homeowner, and that sort of nail and mail or something that's a little bit more than like paper stuck in a door might be the answer. So it serves to the extent that it serves a notice requirement to the homeowner that we're looking for. There are ways to address that, but I appreciate your point about non-appearing versus appearing. In terms of the sales, I guess I would say the foreclosure auctions are profoundly inefficient, and they just don't yield monies either way, whether we're talking about sort of incremental increases in net equity or not. We looked at, for every action filed in 2017, calling 2017 a normal year, right? You're post-Great Recession, but you're not in the pandemic. So every foreclosure that was started in 2017, how many of them went to an auction? I don't have the numbers right here, but I think it's 115 that actually were sold at a foreclosure auction from the mortgage foreclosure standpoint. And something like 60, somewhere between, I will know this, I sorry, I don't know this number offhand. Somewhere between 67 or 70% of those had no bidders whatsoever besides the foreclosing plaintiff. So even then, even with what we're doing with the sign, we're still not attracting something that's helpful. So I understand the point, but we're not seeing the, it might be, only a few dozen sales a year that are actually happening with, to completion. And that's out of, I want to say 12,500 were started. Foreclosure actions were started. So this is still, to me, the specter of the sign is outweighs its value.
But I don't know, and maybe you have this in your data, but I don't know if that takes into account all of the other factors as well. Like there are efforts made to try to resolve mediations, resolve cases through mediation. We have a really, the expanded mediation program to try to help folks along. And there are other things. I don't know, can that all be tied to the issue of I just don't know how much of that is related to the issue of the sign. Do you understand? I'm not articulating that very well, but.
Oh, yeah, no, I would just say that the sign is experienced as an additional stressor amongst everything else without the upside. And we do quite a bit to help prevent preventable foreclosures. But in those situations where they can't be, is there more that can be done? That's all I'm thinking. And a little bit is frankly, like in the same way that, we all know that like I fall 4 months behind and Marshall's not kicking me out tomorrow. Right. But people don't know that in reality. And the same thing goes for the sign. It's many more people are worried about the sign than will ever get it. And so just taking it, the idea is just to take it out as an option. That's all.
Anyone else have anything to add? All right. So, Becky, did you have something you wanted to say? I can't tell if that was okay.
No, thank you. I'm all set, Your Honor.
Okay. All right. So at this point, again, this was informational.
Yeah.
I'll, with everybody's, unless you have another proposal, I will leave this on the agenda for the next meeting for folks to consider what, if any, additional thoughts you have, and what, if anything, is appropriate to consider as next steps.
And if there's anybody who has like any questions or thoughts about like, does this data exist, or does something showing all these different things? There's a lot that's been done, and I'm happy to try to pull it for it. I appreciate people being willing to entertain it. So,
Attorney Gentes, if you have, I don't want to make this a research project for you, but if you have data at your disposal, it might not be a bad idea for you to send that into Becky to circulate so that we have something to look at as we try to digest, the proposal.
What we have is a queryable database. So, Judicial sells a data feed that then can be sort of processed by somebody who can like build a database to do it. And then what we end up with is and it's on the Fair Housing Center side, is I can run queries based on how many times has a motion for approval of sale ever been filed in, actions that were filed between these years, and then you could start like, picking apart things like where there was a defendant lawyer, where there wasn't, and, all those kinds of things. So it's almost like we can, I guess the data there's all the data, but it's just a question of trying to like sort through it, and taking doing the 115 actual foreclosure sales took, having to sort through every possible court filing that signals there was indeed a sale, and then going through and going like, oh, is this just a motion for interim committee fees, or is this somebody that misfiled something or and then you sort through it and you're doing it manually through there. Do you know what I mean?
Gotcha.
Like, so, yeah.
I have a thought on that. And this is maybe giving Becky too much work, but I would think that the branch's bookkeeping in terms of funds held is probably ironclad and easy. Like someone has that somewhere. It may be as simple as how many files had funds received and held by the court pending disbursement from X date to Y date to know how many went third party.
Yeah, I'm not entirely sure, just because those funds are held in trust for each specific location, and
Gotcha.
I don't believe that any of that's all banking accounting. I don't believe any of that accounting then it doesn't tie back into our systems at all on the clerk's end.
Never mind then. I was thinking that it'd be easy enough to know how many accounts were sitting in a trust account, like how many files were sitting in a trust account, etc. But makes sense. Okay, sorry.
If I could add one other obscure fact that I learned from this, but should be to everyone's collective frustration. On those situations where there are underwater properties, and we had, we all underwater properties, but nevertheless we had to go with a sale because federal law required it. As you would suspect, for 2017, zero resulted in any funds to the federal government. In other words, there were no like surprisingly shocking sales. So that part we could guess. I did find an instance in which there was equity and money the federal government was actually entitled to collect. It was like $5,200. They didn't bother, it escheated to the state.
So they didn't bother, and what?
They didn't bother to collect it, and the court then held it for only so long, and then it escheated to the state.
Okay.
So I believe it was HUD. HUD did not collect its money. But yeah, it was like awesome. I'm glad we go through all this this dance for no reason.
Does anyone, and I do this at my peril, but does anyone gather data on the rates that committees charge per hour? To the extent that there is a variance in what we see when we're asked to approve committee fees, I notice quite a range that practitioners are charging. And I don't know if there's any data, any place to look for data on that question.
You could do it. It would take some manual grinding.
It's not could you do it? It's has it been done? Does anyone know that it's been done? I doubt it's been done.
Yeah, no, I can tell you through what I looked through without like being rigorous as to the aspect of things. 225 is the standard, but it's also been the standard for a period of years. That's
and that's the standard
ridiculous.
because it's in the standing order, or that because that's the common understanding.
No, it's like it could be like, I don't know. Jim, the plaintiff's attorneys in this meeting could probably speak more to it, but some of the stuff it's like handed down from Judge Mintz, what he thought in 2012, and never been adjusted by inflation ever since. And then, I saw one the other day, it was for 300, and I was like, it's not unrealistic. It's not absurd for someone who's an experienced attorney to collect $300 an hour, given that what inflation would do to that rate alone.
But it's not that it was even ever written down by Judge Mintz. He just whispered it somewhere, and then it filtered through the firmament.
think so.
I actually have far fewer committees than perhaps most of the rest of the judges here do, but I actually did this within just the last month or 6 weeks because I was seeing some committee fees that I just couldn't live with. And so I had one of my good clerks, he went back and he figured out for each of the perhaps 15 committees that were giving a decent amount of work with what their hourly rates were. And I frankly have since then have issued a cap. I'm not going to, I've got some people who come from way out of the district and, they think because they're from the Stanford area, they can charge $425 up here in Wyndham, and that just doesn't work. But I will say $300 an hour is not unheard of, and that's sort of becoming, I don't want to say it officially, I guess, but I look askance at anything above that, and I'm not finding too many below that, and that's out here in Putnam. So I wouldn't be surprised if the numbers are higher in some of the other parts of the state.
And you'll appoint a committee from Sanford to do a sale in Putnam?
Something happened. It was a strange one. And then they brought their adjuster up, and it was long before I can really jump into it. But it's a huge commercial property, and the appraiser wanted $6,500, and it just got me digging further and further. But there was but anyway, that one's been remedied. But 300 seems to be, and actually I took 2 or 3 of the senior members of the bar out here who do a lot of this stuff, and I canvassed them, and they actually thought that, without wanting to be identified or quoted, they thought some of their colleagues were being somewhat generous with it. And the rule of thumb that I got from a couple of them who I respect was they thought something in the 275-hour range and about 14 hours is what they would think a committee for sale should be looking at. And so I just throw that out for maybe different other parts of the states, but that I thought was at least reasonable, and gave me something to think about.
And it sort of depends on the assignment too. I mean, especially with the way housing is now, there's more interest than there used to be in foreclosure sales. And I've heard specifically, especially in a town, heard one where, the committee had to do quite a bit of work just to field interest calls in a $200,000 property in Simsbury. So that could totally, that affects the amount of work there is too.
I'm just looking to see. I mean, I know that we've had that issue here with people that some committees, the ones that are regularly utilized know, and they charge the same amount, and it's generally in the 250-ish range. But again, 300 doesn't shock me. But if it were higher, I would have an issue with it too. And I know we've had a few, but for the most part, that's not an issue. And for some reason, I was just looking to see if there was an order on it, but I can't find it right now. So my apologies for that.
Last time I checked, we don't conscript people to be committees.
Right.
I don't think.
And I just pulled the list out of my desk drawer here. I have 27 committee names. So again, we're a small jurisdiction, but the low was 250. And before recently, I had rates of 350, 325, 400, 300, 250, 300, 250, 3 1/4, 300, 250, 250, 325, 400. 300, 250, 200, 275, 250, 250, 3 1/4, 350, 350, 250, 250. So really, everyone was at 250 or above, and some were creeping well into the 350 range with a couple of outliers at 400. Yeah. And again, in Putnam. So
So Judge Rohraback, was that something that you wanted to propose as something for us to?
I just, just while we're on the topic of the
Sales?
yes, the whole system and how it's serving the public interest.
All right. So does anyone have any other thoughts for how to handle this? Are you okay with the idea of putting it on for the next agenda, giving folks time to consider if there's any additional questions, if there's additional information that you want, if you come up with thoughts between now and the next meeting as to what you think would be helpful for us to glean, we can, I'll ask Becky to accept those emails and share them with me, and then we can figure it out. I'm happy to hear anything else, but I think at this point, that's what I've got on that issue.
Just a thought on that, just so we can have it in the back of our minds while thinking about it. The CD 79 does have an appendix at the back that lists the publication works by district, which back when newspaper publication was a thing as opposed to online, in terms of where, when, etc. Adding a column to that about generally accepted committee hourly rate would be fairly easy in terms of existing items, just doing the data gathering to get there.
Oh, thank you. Yeah, I was actually talking more about Jeff's whole global issue, but I appreciate that. Anyone have anything else on that topic?
To be sure, I accept Judge Rohraback's friendly amendment to expand the discussion.
Yeah, that's fine. And I'm happy to do that. But for any proposal as far as action for this one, are we good? Okay. So now our next agenda for the new business was James's, and I know that you had a report for us that may make this a non-issue, but I wanted to give you the opportunity to share with the group.
Absolutely. I'm pleased to report that HUD seemed very receptive to some of the industry feedback on the issue. As raised at our last meeting, there was concern about a proposed mortgagee letter regarding payoffs and statements dealing with the debt when there was a HUD partial claim and needing to provide information about things that weren't the actual mortgage, both ethically and on the numbers, etc. The HUD clarified that with a new mortgagee letter or proposed mortgagee letter on their drafting table about 2 weeks ago, 2025-02, which changed it to just when providing a payoff statement, only taking care of anything having to do with other statements of the debt. Lenders are required to provide information to a homeowner to obtain the payoff on their partial claim. So rather than including the partial claim numbers, it's including partial claim contact information. So no worries, nothing on our end, much ado about nothing, but there was a moment of panic, but resolved.
That's great. Any questions for James? I think it's always better to raise the issue, and then if it's resolved, that's great too. So any questions for James? All right, thank you for doing that. Is there any other business to be addressed? I know this was a longer meeting than usual. We had a couple extra kind of meaty issues, and I thank everybody for the extra time that you put in today. Any other business to be brought before the committee? Hearing none, then you have our next meeting date, and I would entertain a motion to adjourn.
So moved.
All right, I'll take that as a motion in a second. Motion,
Perfect.
Jeff, second by James. All those in favor?
Aye.
Thank you so much, everybody. Have a great evening.
All right,
Thank
thank
you.
you.
Thank you,
Thank
Judge
you as
Bailey.
well.
Thank you.